Salam and good day. So in this next series of the chapter, so we are going to learn more about the elements of the offer, which is the second one. They call it the acceptance, because once you have the offer, you must have the acceptance of the offer. So for the acceptance, right? In Section 2B Contract Act 1950 say that when the person to whom the proposal is made signifies his assent thereto, the proposal is to be accepted. A proposal, when accepted, becomes a promise. So this is what the mean is. The proposer, the proposer which is had the proposal is made signify is his assent, because this is what you call that, to approve the proposal, and then the proposal said to be accepted. Okay, this is a proposal. When you have the offer, then you have to accept it. When one party introduces version conditions to the terms of the latest proposal, there is no acceptance. So this is what happened when the other party put another rules when the offer is there. So means that there's no actually going to be acceptance at that particular time. Okay, such variations conditions amount to a counter proposal offer, so there's no agreement. So when you offer somebody, right, and then he counter back the proposal, at that moment there's no agreement had been bound. Okay, so this is make sure that you understand, because it's just like still a bargain method, so still the acceptance is not there. Okay. So another element of the acceptance is the acceptance of the proposal must be absolute and unqualified by virtue of Section 7A. So it must be absolute, it must be there. The acceptance must be there. For the case of Hyde versus French, this case, right? If you go to the stories here, this happens when the defendant, they call it defendant. Okay, we have the defendant here, defendant versus the plaintiff, right? Plaintiff is the defendant. So defendant is the person being sued or being charged, of not being charged, being brought to the court by the plaintiff. Okay, so the defendant offered, so this guy offered to this guy an estate. Okay, PI is plaintiff, on 6th of June of £400. On 8th of June, he replied counter proposal to purchase as 950. So that is 100 and 950. So he counter offer back. And then this guy, the defendant, refused to receive this one. Okay, by 27th of June. Then this plaintiff, okay, because of he already rejected the offer, the counter offer, so he asked again, and he was prepared to pay for the full sum of this one. And after that, the defendant do not sell the estate to him, and he brought this guy to the court. And eventually, the court held no contracted existence between them, because you can see that the case here, this is the counter offer. After the offer has been made, there's no acceptance over here. Then it's void already. So he has to wait for another offer, then he can agree for that particular price. So in this case, he come back with the price. He come back with the acceptance after he counter proposed. So the court say that's no contracted existence between them. Okay, so it means that the acceptance must be made within a reasonable period of under section of 60B. See, so this is B is the act for the that we don't know over here. Okay. Okay, elements of acceptance, more on this one. The acceptance must be expressed in some usual and reasonable manner. So the acceptance must be expressed, unless the proposer prescribes the manner in which it is to be accepted under Section 7B. So in this case, right, of course, when you want to accept it, you must express how you want to express it. Very reasonable, right? Unless the the proposer asks you to do it here and there, based on what is this, so you are following that one, then you're actually accepting the element, you're accepting the offer. So this is how the elements for the acceptance here for this section 7B. Okay, you can read this one. This is more on the law terms, but the most important thing is it must be reasonable to show that you you agree to the offer. Alright, then you have to do the communications of the acceptance. The acceptance is only effective when it has been communicated. This is very important, right? How is it? Okay, it can be made by word or mouth, or letter or telex. This is all communications medium lah. Okay, in England, the communication of acceptance is complete upon posting. Once you post, for example, you agree with that one, right? You post it, it's already communicated and accepted. Okay. In Malaysia, the Contract Act stipulates different times when the communications of acceptance is complete. When the so you have two conditions. One is to the offerer, and the other is to offeree. Okay, so the communications of acceptance is for the offerer is when he puts in the cost of transaction to him. So he won't start, means the communication for the offerer started, and to offeree when it comes to the knowledge of the offerer. So it means that once the offeree knows about the transmission from the offerer, then there's a communication happen for the acceptance. Okay. Okay, in this case, so we look at this case, right? So this is case Ignatius versus Bell. This is because of the whether the acceptance is there or not. So what happened here is the plaintiff sued for specific performance of the option agreement over here. So this option was to be exercised on before 20th of August 1912. Okay. Okay, the parties have negotiated the use of the post as a mean of communication. So this is 1912, so they're using post, not post laju. Okay, the plaintiff sent a notice of acceptance by registered post in Klang on 16th 12. The closing is on 20th. But it was not delivered till the evening of 25th of August. Expired from this one because the plaintiff was away. Okay, the letter had been reminded in the post office Kuala Selangor until picked up by the defendant. In this case, even though right, it was not delivered till the evening of August 25th, but the notice of acceptance had been registered at or on 60th of August prior to 20th, so which means that the court applied by section 4 just now held the option was duly exercised by the plaintiff when the letter was posted on August 16. So the notifications, alright, the communications of acceptance is there, so it means that the offer had been accepted. Okay, this is based on the timeline. Alright, okay, this is the same one just now. Okay, court held that there still can be an agreement. The agreement is there because the offerer just now having no knowledge of the acceptance because he just received it on 25th just now, is bound with the acceptor because he's the acceptant, because now the acceptor sent out already, so he do not know whether he's actually received or not, but because of his acceptance had not come to the knowledge of the proposer, is not bound. Okay, so this is a case. Okay, so this telling you guys when the offer is made, when the acceptance has been done, received, so where's the agreements there. Okay. Okay, next one. You can revoke an offer on acceptance. Okay, but how to revoke it? Okay, so section 541 provide the proposal may be revoked at any time before the communications of its acceptance. So before the acceptance is there, you can revoke the offer. Make it fast. I mean, before you the agreement had been the offer had been accepted, you can revoke it. Okay, so it's complete as against the proposal, but not afterwards. Okay, provide that proposal may be revoked at any time before the communication of the acceptance is complete as against the proposal, but not afterwards. So if the acceptance is accepted, the offer is accepted, so it's different case. Okay. So for the case of revocation, a proposal may be withdrawn in any of the following circumstances. The first one, communicating the notice of revocations by the proposer to the party to whom the proposal was made under section 6A. Okay, this is, you tell them the notice of revocations. The second one, the time prescribed in the proposal for its acceptance elapses. So it means that if there's no acceptance between that particular time, or if there's no time is prescribed for acceptance by the lapse of reasonable time under section B. So if there's no prescribed time acceptance, so you will follow this one. But if you in the offer stated there's the time between here and there, so if the acceptance elapses, so it's been revoked. Okay, the failure of the acceptor is to fulfill a condition precedent to the acceptance under 16cc. Of course, when you do not comply with the acceptor requirement, so of course the offer is revoked. Okay, and the last one is the death or mental disorder come to the knowledge of the acceptant because acceptance under section CD. So the person who give the offer die or have this mental disorder come to the knowledge of the acceptant because before acceptance. So this is called sort of revocations of the offer. So the offer is void. Okay, communications of the revocation. So it completes as against the person who makes the revocation when it is put in the course of transmission to the person to whom it is made by virtue of sections. So it's completed as against whom it is made by when it comes to his knowledge by virtue of section B. This is the completion of the communication based for the person who put the offer, and also completed as against who made based on the for the person who received the offer. Okay. Alright, so this is just the communications of the revocation. Right. So the second one just now is about the offer. The first one is offer. The second one is acceptance. And the third one is considerations. Okay, what is the considerations? Consideration is what distinguishes the bargain or contract from gift. So in section 26, the general rule in a contract is that an agreement without consideration is void. So you must have the agreement to make sure that the offer is not void. It's your agreement. Okay, in this section 2D, define the word consideration is when, at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or abstain from doing something. Such act of abstinence or promise is called a consideration. So this is what the definitions of the consideration. So abstain is refrain. Abstain is refrain here. This is refrain. So this one is sort of following the rules. Means that you are considered to receive the contract at the bargain. So you want to follow the rules whatever been there. Okay, so this one like this, when at the desire of the promiser, the promisee or any other person has done or abstained. This is sort of lawyer terms, but this is just to say that if the promiser wants you to do this one and you consider want to do that, you are going to agree with the terms and conditions, something like that. So you are actually try to put a considerations on it. Alright. The next one is something of value in the eyes of the law need not to be market value. Hence the saying consideration must be sufficient and not accurate. This is about the considerations. Okay. So consideration must flow from the purpose in respect is any promise. So this is sort of like it can be anything for what. For example, it may consist of money, goods, promise, suffering, some detriment. This is consideration, what you have to put in that considerations. Okay. So we have three types of considerations. The first one, they call it the past considerations. which is something being performed before the promise was made. Okay. This is perform, means you have to do something before the promise. Executed consideration is the act which is done to fulfill the contract. And the third one is executed consideration is an act or promise that will be done in the future. This is future, so this is which been done to fulfill the contract. And the first one is the act being performed before the promise. So this is elements of the considerations, right? The types of consideration that we have. Okay, you can have this one, the definitions of this one over here, and this is about the considerations. Okay, so that's the third one. So the first one we have the offer, and the second one we have the acceptance, and the third one we have the considerations. So this is the following process of a contract. And the next one is intention to create legal relations. So if you have all the considerations done, so you have to start thinking about to create a legal relations. So what is this? So all contract is an agreement, but not all agreement is contract. So all contract, of course, you already have the agreement, but agreement, of course, sometimes you just agree, but that it is not as a contract. Okay, so the intention is the most important element which will change an agreement to contract. So this is the intention that you need to do. You just cannot make a promise like that, so you must have to start to have the intention of the legal process. Okay, although the contract is silent on the intentions to create legal relations as one of the requirements of valid contract, case law clearly dictates that necessity of the requirements. So this is very, very important for you to bring somebody to the court. Okay, so the both parties must intend that the agreement is to be binding on them. So you have the legal things that this is you should do, this is what I should do, whatever. This is all thing about the legal, right? Okay, so both parties must intend that the agreement is to binding on them. All right. Next one. So this is a case, for example, a case, right? This is a Balfour versus Balfour. This is a married couple who live in Sri Lanka, returned to England for a vacation. Okay, the husband later returned to work in Sri Lanka back, but the wife stayed back in England on doctor's advice. He promised £30 a month until he returned. Later, he wrote to the wife saying that it would be better if they remain apart. The wife sued him on the promise to pay her £30 a month, but the Court of Appeal held that the arrangement was made between husband and wife was not a contract attended by the legal consequences. So that's why this is more like a legal things that you have to sign, something like that. Okay, by talking like this one only, it can be not strong enough for the agreement. So the presumption that there was no intention to contract was not rebutted by wife. So there is no legal arrangement over here. Therefore, they were presumed to have no intentions to contract. Okay, that's the case, right? And then, okay, the fourth one is just now is the intention to create legal relations. So the fifth one is the capacity. So who are the person allowed to do these legal things, legals relations? So look at here. So what is capacity? Capacity relates to the parties entrance to the should be competent. This is the one to the contract according to the law which is subject and a son of mine. This is not crazy lah, something like that. So this is be competent. It's competent for the contract. Okay. So in principle, every person is qualified to contract. So all of you are qualified to do the contract. Okay. Okay, so the question is, who is competent to contract? So who are they? So only 3 of them. Later, hold on. So this is subsection, sorry. So who are they? Okay, like this one. So every person is competent to contract who is of the age of majority. So this is a term, age of majority here. For example, in Malaysia, we start around 18 and above. So every person is competent to contract who is of the age of majority. So this statement states that lower than 18 is not competent. Okay, so according to the law to which is subject, and who is of son of mine, this is not crazy, and this is not disqualified from contracting by any law which is he is subjected. So 3 of them. Okay, so this is a case, one of the case, contract by minor. Minor means that under 18. For the case here, right? Okay, the Contract Act does not explain the effects of contract made by a minor. Okay, it states that all agreements are contract if they are made by parties competent to contract. Means that the result, in short, every agreement by minor is not a contract. So that is the capacity. So 3 of them. One is average age, second one is the son of mine, and the third one is not disqualified to do the contract. Okay, capacity as to age. So according to the Age of Majority Act 1971, for every individual person, the age of majority is 18 years old. This is for Malaysia lah. Okay, this is the capacity as to age. Okay, for the age, this is our capacity. Okay, this is another one. Every agreement made by monies is not a contract. It's the same thing. For example, just example, Ahmad, who is 13 years old, enters an electrical goods shop and purchases on installment a television set from Ibrahim. When Ahmad fails to pay the installment, Ibrahim sues Ahmad for breach of contract. But this is not going to be a winning thing because Ahmad is 13 years old, is under 18. For the capacity, for the age is totally for lower than 18, the contract is not there, right? Okay, this is another case. I think you can read this case, which is the same thing. As long as it is a minor, the contract is not there between them. Okay, because this is based on the capacity sections of capacity, the elements of the offer. Okay, this is another one, same again with the case of minor. Even though the capacity is a must thing for do the contract, right? But there is an exception for the case, for the capacity. So what is the exceptions for the capacity? Although a contract entered by minor is void, nevertheless, there are 3 exceptions to this general rule when the contract is still valid and enforceable. So even though the contract is by the minor, but there is some cases, I mean, there's exceptions for it. So there are 3 of them. Okay, just to look at that, on the section 69, if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So what is it saying? That the Contract Act, okay, for this section 69, allows a person who was supplied necessary to the minor, okay, the minor, this is the person who supplied, to be reimbursed from the property of the minor. So there's another person can support the minor. So this is just the contents of section 69. So we are looking at the exceptions, the 3 exceptions here. So what are they? The exception is based for the case of age of majority, which is the minor case, right? The minor under 18. This is under 18 years old. Okay, the first one is the marriage by contract. Okay, so this is going to be 18 years old, right? So this is 18 years old. Okay, we are looking at the first one. The first one is the contract is performed based on the marriage. Okay, let's say that this is a very simple case. Let's say that the person is under 18 years old and is having a contract for the marriage. So the marriage is something that different is covered under different sections. So this is the section. The second one is for the case of an act allowed any under law. There will be laws which is going to be can be used for the person under 18 years old. And the last one is the contract for necessary, which is the necessary for the minor person. Okay, so we're looking one by one for the accession case. The first one, for example, that we have the case for the marriage. Okay, so this is the marriage case based on Rajeshwari Anor versus Balakrishnan Rs. Okay, the fact is that the parties to this action were Ceylonese Hindus. Okay, the second defendant, father of the first defendant. So we have the defendant, the father, and the person who wants to get married, which is is the son. Right? Through go-between approach, is the second plaintiff, father. So the first, the plaintiff is the groom. Sorry, the brides, and the plaintiff is her father. In order to arrange a marriage between his son and the second plaintiff daughter. So the person who sued is the brides, and the one being sued is the grooms. Okay, a few days later, members of the two families met and drew up a written agreement. Okay, this is the agreement by the minor. Okay, with provision for a dowry of 50,000 and 5,000 for breach of the agreement, known as the penalty clause. So if the marriage is not performed, so they are going to have the breach of contract. Okay, so to effect the marriage, next morning the ceremony of initiatum, the customary manner of ratifying a betrothal, was performed, and at which the second plaintiff presented the defendant with a gold sovereign. About 2 weeks later, the second plaintiff also presented the first defendant with a shirt, a dhoti, and a shawl, and the first defendant in return presented first plaintiff with a sari and a piece of material for making a blouse to go with it. Subsequently, okay, the first defendant repeated his promise to marry the first plaintiff. Okay, so in this prison proceedings, the plaintiff claimed inter alia. Okay, because the one who don't want to get married, right? He's trying to go for the damages against the first defendant for breach of promise of marriage. Okay, the first defendant pleaded inter alia the incapacity of the first plaintiff to enter into the contract to marry, she being a minor then. Okay, so but the thing is, the court held that when defendant broke his promise of marriage with plaintiff, the defendant was, according to the religious practice, in breach of his contract of marriage, even plaintiff was a minor. So there is an exception for the case of the marriage. Okay, this is the accession for the age of a majority. So the next one is we are looking at the act allowed under any law. So we are looking at the laws that we have over here. Election Act is 21 years old. Okay, so this is not yet here. Act will be not going to be for the 18 at the moment, right? So we have the Employment Act, which is about 48 years old. Okay, so this is minor. So you also have the scholarship. For example, after from 5, 17, 18, 17, you can get the scholarships, alright. And then the Insurance Act, she's 10 years old with consent. So this is the act, which is okay, which is not void, even though it's being used by the age of majority. Right, so the addition is not here, but it's supposed to be here because it's 21 years old. The two main thing is the three main here is about the Employment Act, the amendment of a Scholarship Act, the Insurance Act. So this is the act which is not void for the minor. Okay, let's look at the last one, which is the contract for necessary. So what is it? The contract for necessary for the minor, okay? Contract Act 1971 did not define the service that necessary for minor's life. Minors can't avoid, okay, can't void a contract for items that are considered necessities. So these items, okay, the minor cannot void any contract related to this, because this is what is the necessity for the minors, okay, because it's not 18 years old, so this is the thing that the minors has, right? So that is for the three exception, okay, three exception for the case of the age of majority. So the rest, the most of the case for the minor is void. So you can look back at the example before. All right, thanks. Okay, the next one related to the capacity, right? So back to the first slide for the capacity. So they are talking about the parties entering into contract should be competent. This is the one that we had discussed, to a contract according to the law, which is subject to of a sound of mind. So this is the definitions of sound mind. All right, sound mind versus unsound mind. Okay, this is what the mental capacity. Whether you are not crazy, you are okay, something like that. A contract is formed pursuant to consensus of mind on a matter. So what is the significance of soundness of mind, and what is an unsound mind? Okay, so the definitions of it, right? So unsoundness of minds, which causes incapacity to contract, covers usual unsoundness of mind and occasional unsoundness of mind. So you just can say that the person who is not who is crazy, I mean who's not in a good mental state, can cause the incapacity for the contract. Okay, so it's very simple. You should not be crazy, or you have to be very you call it a sound mind, so to make it the offers, I mean the capacities there. Okay, so this is section 12, right? This is about the act. A person who's sound of mind can make a contract if at the time when he makes it, he is capable of understanding it and forming a rational judgment. So this is very clear. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is sound of mind. So this is just temporary crazy, something like that. It's temporary, just like that. But to make sure that when he make a contract, this is when he is in the current state, good of mind. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is unsound mind. So it's just another words for this one. So may not make a contract when he's not of unsound mind. Alright. So according to English law, a contract made by a person of unsound mind is not void contract but voidable at the options of the party who is of unsound mind. So means that again, just now, this is the one just now, he's not really that good in mind, so he's still doing it, but to make sure that it can be avoidable when the party is options is of unsound mind. So you can make the offer, the capacity is there even though he's unsound, but when the contract is made by him with the time when he's mine, so the contract is there. Alright. So this is the same definition as for that one, so I think should be you just can understand very clear on that. Alright. So that's one the complete of the second lecture. Thank you very much.